So today is the second installment of the Know Your Rights series, part of our International Student Wellbeing Program run at Tenants Victoria, which is being supported by Study Melbourne. So today we're going to be discussing the laws in relation to the Residential Tenancies Act 1997, as well as some of the new amendments that have come into place as of the 29th of March 2021. So basically, the last episode, if you attended, Georgia was there with us as well, which is one of the lawyers in Tenants Victoria. She's been unavailable. She's unavailable today, so it's just me running a solo show. And just as a recap on who I am, I'm the International Student Outreach Worker. I'm also one of the lawyers at Tenants Victoria as well, but I'm currently coordinating the International Student Wellbeing Program. So my contact details are here on the screen, and I also put down the number for the tenants advice line as well, in case you have other friends or family members that might not be international students. They can seek advice through there. If you're an international student, it's probably best if you contact myself, just so you avoid having to wait in the long queues. So basically, this episode, the last episode was just on some of the foundations and the fundamentals of a tenancy. Today, we're talking about what happens if you want to start a tenancy and what are your rights, what are your obligations in that space. And so as a quick recap from our last episode, some of the terminology has changed as of the 29th of March. So a tenant is now a renter, landlord is now a rental provider, a real estate agent is now still a real estate agent, or an agent for short. A rooming house operator is still a rooming house operator, and a lease is now a rental agreement. Of course, you can still use these terms interchangeably. Sometimes I might still slip and use some of the old terminology, but in terms of the legal terminology now, it's the renter, rental provider, rental agreement. So we'll try to stick to that for consistency, but I do apologize if I revert back to some of the old wording. With the rental agreements, some of the things that we discussed in the last episode were rooming house situations, co-tenancy, share house situations, and subletting situations. And there's different types of agreements depending on whether you're in a fixed term, a long term, or a periodic lease. So this is just a bit of a table. In some instances, prescribed forms must be used. And so that was all discussed in the previous episode. So if you're not too sure what a rooming house is or a co-tenancy or what subletting is, we went through all that in the last episode. So it might be good as a refresher. That episode was also recorded and isn't yet available on our website, but will be shortly, fingers crossed, sometime this week, because I would like to get that content out to you guys. But yeah, that will be made available shortly. In terms of some of the things we're going to be discussing today, there's some new forms that are going to be out there in the blogosphere now. So it's good to know what they are. And so I'll preface it here, but I'll go into more detail throughout the webinar. Basically, we're going to go through the new statement of information for applicants, some of the new rental agreements, which we went through in the last episode. So I won't really go through again. If you want to have a look at that, again, refer to the previous episode. It'll show you what the forms look like and when to use them. And then the other thing we'll be discussing today is the new standard condition reports. So all of these forms can be accessed through the Consumer Affairs Victoria website. Usually they'll be provided to you by the rental provider or the real estate agent. So you usually wouldn't have to go prepare this yourself, but it is there as a resource if you need it. I am also going to use rental provider to also mean real estate agent, depending on whether the rental provider engaged a real estate agent to manage their property or not. So if I say rental provider, it also means real estate agent if they've engaged someone. So basically what we're going to be discussing at the moment is, what do you do before you enter a rental agreement? What are some of the things you need to know? How have they changed? Just something that I wish everyone knew before they entered, because we want to be proactive, not reactionary. So it's always good to know what your rights are before entering into something, or even considering entering into something. So basically, the first thing that you do when you find a property that you like is you fill out a rental application. So this is what a rental application looks like. It can be found on the Consumer Affairs Victoria website, or you can ask the real estate agent or the rental provider to provide one for you. And it's usually just giving all the information needed to the rental provider or to the real estate agent for them to make a decision or not, to make a decision on whether or not to rent the property to you. So if you were here pre-COVID, you might know that the rental market was very hectic in its simplest terms, and it was very competitive. And so your rental application was basically your resume, your first point of contact, and your rental provider's insights into who you are and why they should give you the property. So basically with a rental application, normally it includes the form, which is this one here. It will list the people that are living at the property. So if you have kids and other people that might be there but might not necessarily be on the lease, any pets that you may choose to bring to the property, if you already have pets with you and what type, so you can see that in the pet section down there. Details of your rental referees. So these are reference letters provided by previous real estate agents or by rental providers. It doesn't have to be a previous real estate agent or a rental provider. I want to stress that as much as possible. It can be anyone. There's no legal requirement that it has to be a real estate agent or a rental provider. So when it says references, it's literally anyone. You can also provide character references as well. And in terms of information about your employment, that's just to make sure that you can meet the obligations of your rental agreement. Sometimes a form of ID will be asked and it may be scanned, but in saying that, the data that you provide to the rental provider or the real estate agent is protected by law. So personal information cannot be used beyond what is required for the person to make the assessment of your tenancy application. So they can't be they can't be giving your details to external third parties without your consent, without your agreement, because they can only use your information in the scope that you have provided to them, being to apply for a rental property. So in terms of some of the new rental applications, the first form we're going to discuss is this statement of information document. So this is new to accommodate some of the amendments that came into effect on the 29th of March. And so now, basically with this document, it's just letting you know your rights, what can be asked, what can't be asked, what's going to be used to determine your application. The rental provider can't look at certain attributes and make a decision on those. And that includes things like your age, your gender identity, your political and religious beliefs, whether you're pregnant, whether you have kids, those kind of things. They can't unlawfully discriminate your application based on any of these criteria here. And it will tell you what area of the law they may be discriminating or, breaching if they do make an application if they do make an assessment of your application based on any of those protected features and attributes. So it also means that with rental applications, they can't ask you those details either. So, there's certain things that they can no longer ask of you. And those are things like at the bottom here, the ethnicity, gender, disabilities that you may be facing or have vulnerability factors with. They can't ask whether you have been to VCAT previously for another tenancy matter, or whether you've taken your rental provider to or made an application against your rental provider at VCAT. They can't ask you about your bond and whether there's been any claims against your bond by the rental provider at a previous property, or whether you used a guarantor as a bond instead by a third-party organization. And they can't ask for bank or credit card statements. So employment details are fine, because again, that's to make sure that you have the capacity to meet the obligations of your agreement, but you shouldn't need to get to the point of showing them your credit card statements. Again, I should also mention though that you can provide these details to them if you feel comfortable, but they can't ask you for it and they can't make you feel obligated to provide this information to the rental providers for them to make an assessment. Some of the other things that you should also note as well is some restrictions have come into place as to how advertising is going to be conducted moving forward. So back then there may have been like, an advertisement for a property showing the price is between 300 to 350. Now they can't do a range like that anymore. It has to be a certain amount. It has to be specifically $310 per week, for example. And there's no bids or requests for bids anymore. So, prior to COVID, the rental market was quite hot, and there was, properties were flying out the door. So then if someone found a property and then someone else wanted it, they may try to up the bid by like $10 a week or something like that. That can't happen anymore. It has to be a set range. Again, that's just to make sure that it's fair and that, you're not getting the property that you expected ripped out from underneath you because someone else put, a slightly higher bid there. In terms of what the rental provider must disclose to you now. So this usually happens around the same time you make the application. There's no specific time frame as to when things need to happen, but it is prudent that you try to get this information before you sign any agreements, just so you know what you're signing yourself into. So basically, the rental provider needs to tell you whether they have appointed a real estate agent to sell the property. So I apologize, my dog is here. Monty, chill out, buddy. So with the selling of the property, if they've engaged a real estate agent to sell the property, they must tell you so. If a mortgagee, so a bank or a financial funder has enforced their right to pull the property back because the real estate agent or the rental provider hasn't been able to pay their mortgage, then the rental provider must tell you that. If the rental provider is not the owner and they might be the child of the owner, or they might be subletting the property, they need to let you know that, and they need to let you know whether they have the right to let the premises or not. So usually in the instance of a subletter, I use this example because we discussed it in the previous episode, the subletter is someone that rents the property, then they choose to rent the property out again. They're technically not the owner, but in a subletting situation, you can re-rent the property, but it's just a matter of making sure that they have the right, the approval of the rental provider or the owner to do that in the first instance. The rental provider must also let you know whether there's asbestos or mold at the property. Some of the new things that are coming into place is that checks need to be regularly done. And so then the rental provider should be aware of whether there's any asbestos or mold at the property. And some of the other things that they may need to include in the future would be repair notices for any gas, electrical, water, those kind of services, if there's anything wrong with them and if there's anything that needs to be fixed with them. And they will also need to tell you whether there's an embedded network at the property. And so an embedded network basically means that a power or a gas company that basically is the only organization that can service that property. So, with gas providers, there's usually multiple providers that you can choose yourself. With embedded networks, you don't have that choice. You have to use that one power or that one gas company if it's an embedded network, which is different to if the rental provider is saying that you need to use this company because it's their preference. That's not the same thing as an embedded network. Embedded network means that only that provider has the capacity to service that property. So basically, after you have a look at the property, you decide you like it, you make your application, you get all those details, now you're all good to go. You're getting to the next step now, which is entering a rental agreement. So basically with a rental agreement, I showed you the form in the last episode and what that looks like, fairly straightforward form. But basically some of the additional things that the rental provider is going to need to provide to you. And, it's going to be a bit more extensive than the previous form, which was only like 2 pages. Now it's like an 8-page kind of document. The rental provider must provide free methods of payment. So, if you're doing a direct debit or, you're paying cash, they can't say, oh, if you pay direct debit, it's going to be 1.5% surcharge or anything like that. There has to be one free method of payment. You need to also choose whether you want to consent to electronic service. So this was in the previous rental agreement as well, but it was very vague. Whereas now it specifically says, do you consent for electronic service? And electronic service basically means, do you consent for correspondence to be received via an electronic means, so usually by email. So electronic or service in general means, if the rental provider decides to start a VCAT application, they'll serve you via email. If they want to issue a notice to vacate or a repair notice, that if you tick yes, that means they can send it to you via email. If you don't want that to happen and that you want them to send it by post, so you have that hard copy, then don't tick that box. With professional cleaning terms, it basically is a box that will be ticked by the rental provider if they hired a professional cleaner prior to you moving in. That's going to change some of your obligations for when you leave the property. It means that you will need to also return the property in a professionally clean manner, usually by hiring a professional cleaner at the end. With an owner's corporation, if there's one applicable to the premises, that needs to be ticked and the rules need to be provided to you. With the safety related activity statement, that means that it will show that the rental provider did the checks for the gas, electricity, smoke alarm detectors and stuff like that, and or if there's anything that needs to be fixed in relation to any of those services. With a modification agreement, that's usually a discussion between you and the rental provider. If you wanted to paint the house, or if you wanted to add hooks in certain areas or hang things up, those are things that you can reach an agreement on beforehand if that's something that you intend to do moving into the property. And pet provisions as well will also be in the rental agreement now. And if you want pets and whatnot, you do have to ask for permission. If you're not too sure how those provisions work, Georgia on our Facebook website, on our Facebook page, has created a really good short video on pet provisions and what that means for the renter. With additional terms, they may be applicable if it's not prohibited. I would check in with either myself or by calling through to Tenants Vic if you're not sure whether it's a prohibited term or not. It is quite extensive, so it's not something that I have the scope to cover in 30 minutes. But basically, some of the prohibited terms may include, the rental provider requiring that you take out insurance, or signing indemnity saying that you're not going to make any claims against the rental provider, or making you use third-party services to professionally clean the property, or mow the lawn, or anything like that, or any terms saying that you need to pay for the preparation of the rental agreement. Those are some of the terms that can't be added. There may be some terms that may be okay, but again, check with us if you're not sure. With the next slide, we'll go into bonds. So those are some of the things that you should be considering in your rental agreement. But basically, if you're not sure, rule of thumb is check with us. With the bond, this usually happens before you move into the property. So can happen at the same time when you sign the agreement and return it. But again, things get a little bit messy in the practicality of it all. So it's prudent to kind of go through this with you now. With the bond, it's basically money that's asked by the rental provider or the real estate agent to be paid at the start of your tenancy. And so any money that is paid is usually, or it must be, lodged with the Residential Tenancies Bond Authority. That's a third-party organization that holds your money in trust. And so it needs, once you pay that money to the rental provider or the real estate agent, they have 10 days to lodge it. And usually they'll get you to sign a form, or if you're happy to do it through electronic means, they'll fill out a form on the RTBA website, which looks like this. And then you'll get an email saying fill out your details, and then it'll be lodged. So with the bond, you'll normally get a receipt back from the RTBA within 7 days, and you'll include a bond ID, which is basically your reference number to show attaching the bond to your name, essentially. And so with the bond, you usually only pay about 1 month's worth of rent for a bond. Sometimes it can be higher, but you usually need VCAT's approval for there to be a higher bond, or if the rent is more than $900 per week. So usually it is just the normal month's amount, and sometimes you'll be asked to pay a month in advance. So that's the bond there. With rooming houses and share houses, it's slightly different. So with a rooming house, the bond can't be more than 28 days worth of rent. So, figure out your rental amount per month or per week, however you pay it, times it by a year, and then divide it by 365. No, that's a bit complicated. Okay, so basically, if you get the daily amount of your rent, and then times it by 28 days. That's how much your bond should be. With that's if you're in a fixed term agreement. If you're in a periodic month by month agreement, again, if you don't know what that means, the first episode goes through all that. You only need to pay 14 days worth of rent if you're in a rooming house. And if you don't know if you're in a rooming house, again, the first episode will go through that and help you identify whether you are or you aren't. With share houses and co-tenancies, this gets a little bit complicated and it gets a little bit messy, because anyone that's on the lease will usually pay for the bond, or contribute to the bond, and then so when the bond is lodged with the RTBA, their names will all be listed on the bond as well. So with the if someone leaves or if someone joins, it gets a little bit messy because the bond can't actually be redistributed or released until the tenancy ends. So if someone's joining in halfway or leaving halfway, it gets a little bit difficult, because then the tenants at the household would need to discuss how that money is going to be transferred into who and who pays who, blah, blah. And then you tell the rental provider once you're ready, and then they will sign part of their form to get the RTBA to update the names of the new tenants or the renters at that property. It gets a little bit messy. It does add a layer of complexity to it. If you're not too sure how to go about it, again, get in contact with us. We can have a chat with you about it. And the last thing I should note is that it is an offence not to lodge it with the Residential Tenancies Bond Authority. If you've paid money to the rental provider or the real estate agent, make sure you get a bond ID and a receipt. I cannot tell you the importance of that enough. It's just a protection for you. That's the whole purpose of the RTBA. Make sure that you're getting that enforced. It's not hard to do. Real estate agents and rental providers usually know that they have to do it. If they don't do it, let us know. We can help you ensure that it is lodged with the RTBA to make sure your money is being held in trust on your behalf. So this is what the website looks like. You can go to rentalbonds.vic.gov.au. Once you get that bond ID number, you can pop it into the website here, search it up, and then just to make sure that your bond has been appropriately or correctly lodged with the RTBA. So the second thing that you should also look at, another document, I guess, that you should be getting or considering when you're starting a tenancy is a condition report. So if you pay a bond, you are entitled to get a condition report. The rental provider must provide it to you if the bond's paid. And so basically a condition report is just a record of the property's condition when you first move into the rental property. And so basically the rental provider or the real estate agent will prepare it, saying this is the condition the property's in. There's a little crack in this room. We're well aware of that. You'll get a copy of the document too if it's by paper means. That has already been signed by the rental provider. You'll be able to take that through the property and then compare it for yourself. Always make your own assessment, always take your own photos. Don't trust the condition report blindly, because sometimes it might be, an old one that they've used and hasn't been updated, where, there's a minor crack now, but if you're in the lease for, 3, 4, 5 years, it might eventuate to something bigger. You want to be making sure that the details in the document are correct. Anything that's not, take pictures, get it rectified by the rental provider before you sign it. You normally have 5 days after you move in the property to take your pictures, to notice things that you don't notice in the initial inspection before you return that form signed to the rental provider. Usually it is the rental provider or the real estate agent that will prepare this form. If they don't, you can do it yourself. The form's on the Consumer Affairs Victoria website, but usually it is the rental provider that's supposed to do this for you. I do also want to note that with the pictures that you take, store them somewhere safe, because usually those pictures will come out at the end of the tenancy if there's anything in dispute. You might go into the tenancy expecting to only be there for a year, but you might not leave for another 7 years. It's good to have pictures because you're not relying on memory. You're relying on the pictures to back up your argument if anything arises later on. And then the last thing I want to go through before we kind of end it all, I know there's a lot that we've gone through today. So hopefully, in your own time, you can go back and watch this again. But the last thing we're going to go through are minimum standards. So there were previous minimum standards, but they've been recently amended with the changes. But basically, some of the things that you may already know is that the landlord or the rental provider has a duty to provide the premises or to maintain the premises in a good state of repair. That was the old definition. The new definition now adds an extra layer of, I guess, protections there in that it clarifies it a little bit more, being that the rented premises are to be provided and maintained in good repair and is reasonably fit and suitable for occupancy. So back then, the definition was just maintain premises in good repair. Whatever that means, we don't know. It could be bare minimum, but now it also needs to be fit and suitable for occupation as well. So that's where that added level of protection comes into place. What that means, it's still being developed through the courts and VCAT challenges. At the moment, that's the definition. With quiet enjoyment, it stayed the same, being that the rental provider must take all reasonable steps to ensure that the renter has quiet enjoyment of the premises during the residential agreement or during the rental agreement is in effect. So quiet enjoyment means, things like they can't just walk in whenever they decide to. They have to go through proper processes. They can't have friends and family or lawnmower guys coming through whenever they please. And it also means that, the services and the utilities at the property need to also be able to be used as well, because that's what you're paying for. So with the minimum standards, some of the new things are locks and windows, vermin-proof bins, property needs to be free from mold and dampness, structural soundness, including ventilation, electrical safety, heating, which is one of the newer exciting ones, and basic facilities for kitchen, laundry, bathroom, and toilets. So it sounds a little bit weird, but basically, these are the things. It sounds quite logical that they should be there. They weren't always up to the same standard, so now it's just in writing. So, with the locks, deadlocks need to be where they need to be included in the property where they can be, unless it's like a heritage listing. But at least all external doors need to have locks and keys to them. Window coverings, so being able to open and close blinds and have sufficient privacy with those blinds. Windows that are capable of being able to be opened must have locks on them as well. Don't need keys necessarily, but as long as they can lock either by a latch or a key lock. Vermin-proof bins being, your rubbish bins and recycling bins, making sure that bugs and all that nasty critter stuff can't get in. With mold and dampness, it's usually, making sure that the property is structurally sound and weatherproof. So even if it rains heavily, you shouldn't be getting dampness in the house because there's a missing tile in the roof. That also comes down to ventilation as well. So just because a property is structurally sound, if there's no proper ventilation in areas like a bathroom or a laundry, you're more likely to get mold and dampness. So they do kind of play hand in hand. With electrical safety, a lot of the switchboards are going to need to meet a certain standard. That's not going to come in, that's not going to be required or enforceable until March 2023. So a little way away, so the rental provider can make those changes and adjustments. With the heating, there must be a heater and it must be energy efficient, which back then there wasn't a requirement for heating unless it was already in the property. But now there must be a heater. So yay to the cold winter, Melbourne winters, especially the ones that are fastly approaching. With the facilities, you've got to make sure that in the kitchen you have at least 2 burners on the stovetop, an area for the sink and an area for food preparation. With the laundry, you must be able to access hot and cold water, same as the bathroom, and toilet needs to be, needs to have proper sewerage, and it needs to be enclosed in an area that's intended to be used as a toilet. It can't just be in the middle of nowhere. And then, so basically, this is a bit of a checklist on what we've discussed today. If you want to screenshot this, print this off, kind of just check it, make sure that you're covering yourself before you enter a tenancy. And then that brings us to the end of our episode, which our next episode's not going to be until the 25th of May, the last Tuesday of May, basically. And then we'll be going through some of the things that you may deal with in your tenancy. So some of the common problems that you might have. And then the last episode will be in June, which will be talking about if you want to leave your tenancy, if you get eviction notices or notices to vacate, what happens there.